Hello friends and welcome to StudyIQ. I'm Joycey Joy and today in this lecture we will discuss about Meghalaya High Court's contempt order on Shillong Times. So coming to the current affair, the Meghalaya High Court held the editor and the publisher of Shillong Times newspaper guilty of contempt. So we will see what are the details of it, what are the impacts and why it is considered to be controversial and what are the dimensions of it. But before we move on, this is our channel StudyIQ and we are providing pen drive courses for various competitive examinations including SSC bank courses, UPSC optionals, SSC JE courses, teaching examinations, railway examinations, defense examinations, RBI grade B, NABARD grade A, UGC NET, UPSC Civil Services Examination, CLAT exams for various state PSCs and also for various professional courses. You can visit our website www.studyiq.com for more details or you can call to any of these numbers for more information. So let us start. Let us first understand what is the recent case all about. Now the recent case where the Meghalaya High Court has held the editor and the publisher of Shillong Times newspaper guilty of contempt relates to the state government, that is the Meghalaya state government's unilateral decision to withdraw certain facilities given to retired judges. So even after the retirement of judges, the judges and the family are given certain facilities which would include residence facility or the use of public vehicle, etc. So certain facilities are given to the retired judges also. Now the state government of Meghalaya had taken a unilateral decision. That means without consulting the court administration in the Meghalaya state, that certain facilities that are given to the retired judges and their family would be withdrawn. Now, after the unilateral decision was taken by the Meghalaya state government, this had to undergo administrative proceedings. But the administrative side could not resolve this issue even after 2 months. So what happened? The High Court, the Meghalaya High Court initiated suo motu proceedings. That means it had taken up the proceedings by itself. And following this, the court order had issued some directions seeking better facilities for retired judges and their families. Now, the High Court order was that the state cannot impose unilaterally such decision on restricting the facilities that is given to the retired judges and their families. And also, the court order had sought better facilities for the retired judges and their families. It called for extending the facilities including protocol services, domestic help, reimbursement of communication bills up to 10,000 rupees per month and also a mobile phone worth 80,000. So the court order also extended or called for extending the facilities that are available to the retired judges and also their families. Now after the court order was given, 2 newspapers in the state of Meghalaya, one is the Shillong Times. Now after the court had given the order or the verdict on extending the facilities, 2 reports were published in the newspaper Shillong Times and the reports criticized the decision of the High Court saying that the judges are judging for themselves. This is because the High Court had given a favorable verdict for the retired judges. So the newspaper report criticized the order of the High Court saying that the judges are being judged by the judges themselves. Now, the retired judges were also a part of the judiciary. And now, the present judges in the High Court have given a verdict that is favorable for the retired judges. And this report which was published in the newspaper was criticizing that extending the facilities to retired judges is not completely right because this decision was taken by the court itself. And following these 2 reports which were published in the Shillong Times, the court found the editor and publisher of the Shillong Times guilty of the contempt of court and also imposed a fine of rupees 2 lakh each. And the court also ruled that in case of non-payment of the penalty in a week, the 2, that is the editor and the publisher, would be imprisoned for 6 months and the paper would be banned. So the High Court has taken an extreme measure by finding the editor and the publisher guilty of contempt of court and also imposing penalty on the failure of which imprisonment and banning of the newspaper. So we can say that this is an extreme measure that is taken by the High Court. Now let us understand what is the controversy here. First of all, the court's move on imposing penalty of 2 lakh each seems to be a very heavy-handed response to the comments in the newspaper on the earlier decision of the court. So, the penalty does not end with the payment of fine. If there is any case of non-payment of the penalty, the newspaper could be banned, and this will also attract imprisonment for the editor and the publisher. Now, if we examine this, the judicial system in India or the courts are empowered to decide whether a publication has scandalized or tended to scandalize the judiciary or interfered with the administration of the justice. But in India, there is no legal provision for an outright ban on any newspaper or a publication. Courts can look into or check whether it has scandalized or caused harm to the image of the judicial system in India. But when there is no legal system or provision existing for the outright ban on the publication or the newspaper, the court has made a comment that on non-payment of the penalty, the newspaper would be banned in the state. Now, this has impacted the dignity of the higher judiciary. Now, the higher judiciary, including the high courts of different states and the Supreme Court of India, has the responsibility to preserve the dignity of higher judiciary. Now, in case of Patricia Mukim, the editor of the Shillong Times, the court has remarked that the newspaper had always attacked the individuals and institutions, and it also made a comment that the newspaper has published propaganda calling for bans or hartals, and it had worked against the judges and the judicial system. Now, the real question is that the publisher or the newspaper can always express the personal views. Now, two questions. One, what is the extent to which a publisher or a newspaper can express his or her or its personal views? So that is the first question. The second question is that on what basis has the High Court of Meghalaya decided on the contempt of court? So these are the questions. So now it is controversial that whether it is an overreach of the judiciary or a judicial overreach or hyperactivism of the judiciary. Now, the biggest controversy lies in the fact that to what extent can the contempt law be used in the country. So, whether the contempt law, the contempt of court law can be used in suppressing the views of different newspapers or any individual or any institution in a country, or what is the extent or what is the limit to which the court can use the contempt law. So these are the controversial questions, and it also opens a new question whether it is adding to the judicial activism that is existing in the country, and also whether it is impacting the dignity of higher judiciary and the law and order system in the country. You can find the PDF of this lecture on my Facebook page, and for any queries regarding your preparations, you can get in touch with me on my Facebook page, or you can email me at joycey.studyiq@gmail.com. Thank you.